Judge Eileen Cannon, supervising Trump's current federal indictment regarding Mar-a-Lago and all things espionage, drew a line in the sand and said, trial in August, like Christmas in July, but better. The Department of Justice said, we like where your head's at, Judge, but December is more reasonable given the 6 terabytes of data and classified documents at the core of the case. And now the skipper and little buddy are heard from, Trump and Walt Nauta, with a filing this week in which they asked for an indefinite trial setting, not until after they file motions to dismiss the indictment and teach the judge the law according to Trump regarding Presidential Records Act and the crimes charged, and certainly after the primary and presidential election season. So let's call it 2025. The court will make her decision on the 18th of July, and we discuss what we think will happen next. Hint, we may have a disagreement between the anchors on the show. 7/11 is usually a lucky date, but not for Trump in the E. Jean Carroll defamation case, based on statements he made while president and at the CNN town hall in May. Just yesterday, 2 major events. The Department of Justice, after 3 years and 2 administrations, has told the parties and the court they're out and will no longer seek to protect Trump with presidential immunity for the defamatory statements he made while president against E. Jean Carroll. And they're exiting the case. And on the same day, E. Jean Carroll's lawyers filed a scathing motion to dismiss his defamation case against her as the victim of sex abuse because he wasn't a sex abuser. He was a sex abuser, not a rapist. That's his defense. So, and based on statements that she made on CNN. Will the judge dismiss Trump's retaliatory suit against E. Jean Carroll this summer? And what does it mean for the trial now that Trump can be sued and has no immunity for his comments that he made while he just happened to be president of the United States at the time? Finally, Georgia peaches aren't the only thing in season. Georgia indictments by the Fulton County DA in Atlanta are in season 2. Fani Willis just sat her grand jury of 26 Fultonians to start their work on Tuesday with a target window of August 11th through September 1st to get an indictment against Trump. How many make up a quorum in a grand jury? And how many are needed to vote to indict? Why are there 2 grand juries in place? Why do we see pictures of the grand jury now? And what about the special purpose grand jury report and indictment recommendations from March? All this and oh, so much more on the midweek edition of Legal AF, only on the MeidasTouch Network, with your anchors Michael Popok and Karen Friedman Agnifilo. Sizzling indictment summer may be the reason that the Earth's global collective temperature set a record this week. Karen, thoughts?
It's, I'm feeling very patriotic because, I feel kind of wrapped in the flag right now. I wanted to go for a walk before this podcast and get my head cleared and kind of just get myself ready. And as I was going for a walk, a neighbor of mine got sick and we had to call 911 and an ambulance came, and just watching publics like heroes, truly absolute heroes. They come in an emergency. These are people who devote their life to helping people. They come and they help you, and they're nice, and it just makes me feel very kind of warm and fuzzy inside. And, I really, whether it's police or fire or, EMS or who, to me, those are the people who are the heroes of our country and who need to be celebrated. Just the exact opposite of the people we're about to talk about, Donald Trump and all of his MAGA, America hating, they want to just steal our democracy. But it made me feel so good about people and about just the heroes.
Yeah, it's people are going to think this is weird, even though you and I are in the same city. We had a very similar event happen, unfortunately, a couple of weeks ago in front of my office in Murray Hill in New York, where we sport a giant American flag that proudly waves. My office administrator had to help in an emergency basis a man who had a seizure in the middle of the street on 38th Street, and waited, and he lost teeth in hitting his head on the ground. And she sat with him. He didn't know where he was. He was out cold for most of it. And we waited for EMS and the fire department, the police department to come. And a lot of Manhattan people and tourists and others came to his rescue and sat with her as well. And that was an amazing, heartwarming thing. Although there was one moment that was like out of a Fellini film, a woman in full clown makeup got out of a car to come over to assist, which gave it a whole nother's only in New York
that's
moment.
Manhattan. That's what New York is so great about New York is
right.
You can be anything here. You can love who you want. You can marry who you want. And we all live together and get along. It doesn't matter what color your skin is or anything else. We all come together. And that's why I love New York. New York's not perfect. I'm not from New York originally. And sometimes, it can be challenging. But the reason I'm here and I've stayed here and work here and raised my kids here and here my whole adult life is because of the people. Yeah. It's because the people who are here are diverse, they're interesting, and they all come together and live together and accept each other. And it's what's beautiful about New York.
Yeah, which is so weird that we're going to be talking throughout today's podcast about people like Rudy Giuliani, who used to be the mayor of this great metropolis. Yeah. And boy, have he fallen. And we'll talk about all that when we get to Georgia.
And Donald Trump was from here too. I can't believe,
He's he was hatched. He wasn't really from anywhere. He's from a spaceship. But let's talk about Donald Trump and Walt Nauta, the skipper and little buddy, for those that are Gilligan's Island fans, and the Mar-a-Lago proceedings that are going on. And where are we with it? So I'll kind of give the highlights, the 5,000 foot level, and then we'll dive in with our resident former prosecutor, Karen Friedman Agnifilo. So the court had set a long time ago, at least at the end of June, a hearing that was going to be on July the 14th for both Nauta and Trump and their lawyers to talk about a few things. One, a proposed trial date. The judge having, as I said in the opening, drawn the line in the sand and said, all right, Speedy Trial Act and constitutional right to a fast trial. How about August? We'll do August. And then I think that even caught the Department of Justice a little bit by surprise. And they said, well, we're ready, but the defense isn't going to be ready by August because we're about to dump on them about 7 terabytes of data. Just to put a little fine point on that, in a recent government filing, where they gave the sheer, it was actually in the filing by Donald Trump. I'm going to correct myself here. They listed what the government is giving them. And it's 430,000 records comprised of 833,000 pages of documents, 305,000 additional documents, documents coming from 90 custodians of record, 90 different sources, 57 raw hours of closed circuit TV footage, and up to I said 6. It's 57 terabytes of information, which for those that don't, know, that's a lot. That's like multiple servers worth of just data that's coming to them. So based on that, the government said, you know what, let's do December. December, a very canny choice, because as you and I were talking to our producer Salty tonight, the first primary for the Republicans is January. So this would be before the primaries. Let's get this trial going. And let's not even worry about the March 2024, several months later, trial up in New York related to Donald Trump. Let's not worry about the October civil fraud case up in New York. We'll do December. That seems to be a lane that we can occupy. And as expected, I think Ben Meiselas, our co-anchor and colleague, put it best. They were going to ask for 2025. And they basically have. They said, Judge, there's so many complicated issues here. We're going to have to teach you. Remember the way we taught you last time related to when we asked you to stop the criminal investigation in its tracks and you got slapped by the 11th Circuit, your bosses on the appellate court twice? Remember that? Remember when we misled you about the law? Well, we're going to do it again. This is my words, not theirs. And we're going to teach you about the Presidential Records Act, which, by the way, is not applicable, and the Espionage Act and all the crimes and how they fit together. P.S. They don't fit together. And so we're going to confuse you, and we're going to play that game, and maybe we'll file a motion to dismiss. So it's really premature, and this is a candidate for office, and Joe Biden runs the DOJ, and so let's call the whole thing off. And I mean, I'm giving you a summary, but that's basically what's in the papers. And of course, we're waiting on the Department of Justice. Usually they're lickety split. We get a filing from them within hours. They already have it ready to go in the computer, prepared. Okay, did they file? Okay, filed. Let's file ours. So that's going to come in the next day or two, and Ben and I'll cover that on Saturday. And then you have the judge agreeing to push the hearing off until the 18th, where she's going to do two things. She's going to discuss this trial setting process and whether she does or she doesn't set it. And then she needs to have a required Classified Information Procedures Act hearing, a CIPA, C-I-P-A hearing, to talk about everybody getting their security clearances in place and how they're going to use documents and share documents, who's going to have access to those kind of classified documents, what are they going to do at trial, so that everybody's better informed about how to put on this trial and do depositions or any kind of statements under oath between now and the time of trial before the trial setting. That's why you usually have a trial setting, so you work backwards from there. But Karen, prosecutor, you got a different view about all this. Tell our audience.
So let's just talk about, in general, how cases work when you're in court. We've seen the arraignment, right, where you are told what your charges are and whatever the bail is that is will or will not be set, or release conditions. And then there's also at the end a trial. Okay, but there's a lot that goes on in between, and those are adjournments or court appearances. And in criminal cases, that is usually ones that require the defendant to be present, unlike civil cases, which you don't necessarily need to have. And so there are these adjournments, and they can be for all sorts of reasons. They can be to just update the judge. They can be to ask something of the judge. They can be to have hearings. They can be for all sorts of reasons. And there are different ways that can work in a case. So civil, for example, this is criminal, but in civil cases, normally the way they do it is they set a trial date and then they work backwards and have all the dates in between of when things are due. You know, this motion is due and this piece of paper is due, or depositions have to be done, or discovery has to be done. And if you want to change those dates, it's all kind of preset. There's like this, calculator that sets the dates. If you want to change them, you ask permission for the court. In state court in New York, the way it works is after the arraignment, they just adjourn it to the next date for the next thing without any thought about trial or what's going to be in the future. There's no sort of mapping out the whole case of, okay, the trial will be on this date and let's work backwards. Let's do motions here and hearings here and et cetera. So in state court, like I said, after arraignment, they will adjourn it for the next procedural thing that has to happen. And there's different milestones that you have to reach to get to the next step. But you don't know when the trial is going to be because you have no idea how long those procedural things are going to take. And in federal court, criminal, however, it's a different tradition. The tradition criminally in federal court, because that's really what this is. It's kind of the custom or the tradition of how courts typically do things, is they typically do set a trial date. And it can be moved, but at least it's a goal. And it's a goal towards what you think, when you think it's going to be. Now, in state court also, trial dates rarely mean anything, right? You set it for trial. A case can be on for trial 3, 4, 5, 6 times. I'm not ready because my witness didn't show up, or the defense attorney says I'm on trial. Federal court's not like that. A trial date is a trial date is a trial date. And so you are going to be ready, both sides, on that date, unless you have explicit permission from the court. But it's much more serious and it's much more fixed in stone. And so here, what's going on is, as you put it, Jack Smith is saying it's realistic that this will be ready in December. And the defense team, all of the defendants' lawyers, so both Walt Nauta and Donald Trump's lawyers, all said, there's no way we can be ready by December. And they list all the reasons why. We don't even have our security clearances yet. We haven't even, but P.S., they haven't even filled out the paperwork yet. And, there's a little game going on here, I think, where Walt Nauta is doing Trump's bidding by asking for these little adjournments, like, oh, I can't, I don't have a lawyer. I can't be arraigned. Okay, put it over. Well, I couldn't make it to the arraignment because my flight was canceled. And so put it over again. well, I have a lawyer, but, she just got here, so she can't possibly be ready by July 14th, and so then they all agreed, okay, how about July 18th is when this hearing is going to be. And, some people might say, oh, well, it's only 4 days. What difference does it make? But those small adjournments add up, and it's sort of death by a thousand cuts that I think they're trying to do, because the more they can push it towards the election, even if it's 4 days here, 2 weeks there, 3 weeks there, these little tiny, we're not asking for that much, we'll just put it over, you're eventually going to get into dangerous territory. And that's exactly what they're trying to do. And I think what's going to happen here is, they're giving all these excuses, right, about why they can't possibly be ready. This is, there's so many legal questions that are significant and a first impression. As you said, the Presidential Records Act and criminal statutes have never been addressed by any court. Or, we're going to question the authority of the special counsel. This kind of thing. And so the question is, what is, and we'll go into that in more detail. About, because I think it's worth going into these in more detail. But I just want to answer your specific question of what I think that Eileen Cannon's going to do, and I think she's going to punt. I don't think she wants to get criticized by making the decision. Sure, I'll put this over, until whenever, because we're going to get too close to the election. But I think she'll say, look, you guys haven't even, this 57 terabytes worth of data of discovery that's been turned over, by your own admission, government, you haven't even turned everything over yet. And we haven't gotten the security clearances yet. And we don't even know what we're going to do with these classified documents yet. So I'm not going to make a decision yet. And I'm going to punt it, and we'll see how we do. And she's going to just keep, little by little, and they're going to try their death by a thousand cuts. They're going to push it. And then eventually they're going to say, well, he's the nominee and he can't possibly, he has to be at this primary, or he has to be given this speech, his First Amendment rights. You're going to infringe on them by not allowing him by interfering with his rights to run for office, et cetera. So I think she's going to punt. That's what I think. Mm-hmm.
Popok? Back to you, Popok. Well, a couple things. One, we went through a process like this under the state court proceeding procedures that you outlined earlier with Judge Mershon, who's handling a criminal case of almost as many counts, 34 counts, or as one of the cheeky pro-democracy websites like to say, with a list of former presidents with zeros next to their name for the amount of felonies they've been charged with, and then ending with Trump 71. Mershon, he put it in March. He said, you want it in the middle of election season, in primary season? You're okay. I'm not going to do it before. I'm not going to do it after. But we know this Eileen Cannon, to your point, has bent over backwards and thinks that she has some sort of person with special properties in front of her because he was the former president and now is the likely nominee for his party. I choke every time I come out with that. Once again, to my friends and I have Republican friends, this is the best you can do. The twice impeached, multiply indicted, a judged sex abuser. This is your candidate. Okay. Putting that aside for a moment. We know where her head was at and how easily distracted, and she took her eye off the ball of the law when they ran into court. A different set of lawyers for Trump at the time ran into court to try to stop the criminal investigation and the search warrant in its tracks. And she made some comments in her rulings, pardon me, everybody, in which she said, oh, he's special. This is my words. He's special. He's former president. We have to treat former president differently, with kid gloves. I have to bend over backwards as federal judge. I don't know why I'm talking like Tarzan, but this is sort of the rudimentary observations this judge made, all wrong, by the way. And then she was reprimanded and reproached by the 11th Circuit, her bosses, in two separate panels that said, I don't know what you're talking about, but your role in a criminal investigation is very limited. And you've crossed those lines and those boundaries, and you're doing weird things. Stop it. And the search warrant goes forward. And if there's an indictment issue and a suppression of the evidence issue, you'll deal with that at another time if and when there's ever an indictment. Well, now there's an indictment, but we kind of know that her compass is already a little bit screwy, a little bit cracked. And they're exploiting that, these two new lawyers for Donald Trump, Chris Kice and Todd Blanche, knowing that they misled her, or the other lawyers led her astray last time. She's easily misled. We're going to try it again. Judge, Presidential Records Act. Really complicated stuff, Judge. It intersects, it doesn't, by the way, with the Espionage Act. It only does in Trump's mind because he keeps saying it does. It doesn't. He's not being charged with criminal violations of the Presidential Records Act. He's being charged with compromising national defense information, NDI, and using it in places like Bedminster, his golf course, to show off to friends and family to make his point, showing Iranian war maps. That ain't a presidential record. But they're going to try to confuse her. Shiny object, Judge, look over here. And it's so complicated, Judge, we can't even really get to our motion to dismiss the indictment and dispositive motions to get rid of it under Presidential Records Act application for months. First of all, why? This is July. He doesn't start his campaign in earnest until the primaries in January. He's already told people he's not going to the Fox News debate because he hates Fox News right now. He fell out of favor with them. He picks and chooses which of these crazy events he goes to, moms, Christian moms, and Moms for Liberty, and Mothers for Justice, and all these made up grassroots places where he basically has to pay people to attend and yell his name. And so he, as other judges in the federal system have noted, we just had a ruling by Judge Amy Coney, you can see I got the three names wrong, by Amy Berman Jackson. Sorry, everybody. A democratically appointed judge in the D.C. Circuit, who said in the case involving Peter Strzok, the FBI agent who got canned for expressing his First Amendment rights, that Trump is corrupt, while he was working on the FBI investigation of the Russia collusion project for Mueller, in his civil suit against the government and everybody else for getting canned, he wants to depose Donald Trump. Donald Trump, and even the Department of Justice said, well, maybe not the former president at this moment. Amy Berman Jackson said, well, I've looked at your trial calendar. You're giving depositions up in civil cases up in New York, and you're sitting for them in the class action fraud case that's been brought against you and your family, and a civil fraud case and a defamation case. You look like you have time to sit for a deposition here. So not every federal judge treats him with this effect, this halo effect, the way that Cannon used to. The jury's out a little bit about what she's going to do on the 18th. But having listened to you, I told you I wasn't quite sure what I was going to say on the podcast. I think you're right. I think she's not going to set a date far out. She's going to punt. She's going to say, let me set a status conference. Everybody check your calendars. Let's set a control date of, let's all get back together in November or December, and let's see where we are with the classified documents and the security clearances and the exchange, the documents that you've given over to the defense and the motion practice. Well, we'll set some motion practice dates and deadlines, and then I'll decide in December or January or whoever about the trial date. Now, for those in our chat that are jumping up and down with, she's corrupt, she's going to make the terrible decision, we need to take an appeal, it's going to be very difficult, and the DOJ knows this, to appeal a ruling, a decision by the judge about which date for the trial. That's not appellate grounds. The judges are given tremendous autonomy and discretion to set and control trials.
Especially if she doesn't make a decision.
That's their number one job. Right. Well, the decision not to set a trial date is making a decision about the trial date. And that's gonna be an abuse of discretion standard. The DOJ is never going to win that on an appeal. So we're going to be stuck. So that's why I'm come back around, Karen, to your view that the safest place for her to both appease people on the far political right and whoever else is to just say, let's reconvene in November or December, and we'll let everybody check your calendars. And the Department of Justice is going to be like, okay, great. They're going to have to do it because there's no place else to go on the trial setting issue. It sits with the trial judge, and you can't get her bosses at the 11th Circuit to overturn her. So
the Department of Justice will, Jack Smith's people will bend over backwards, though, to absolutely give them everything as soon as possible, to point out to them exactly what they're going to, where the relevant, there's 9 months worth of CCTV tape is how they call it, right? So they were saying there's 9 months worth of video. How can we possibly watch all that so quickly? They will point out, okay, it's all, this is nighttime, nothing's happening.
Right.
It's from this time to this, yes, down to the hour. And, and look, and that's what prosecutors do a lot, is they'll say, this is the stuff that I'm going to be using at trial. This is what's relevant. But, defense attorneys regularly, what they do is they watch everything else. They look at everything else. The 31 documents that Jack Smith wants to, the classified documents that are going to be the subject of the SEPA hearing, those are going to be, that's going to be very interesting, because Jack Smith has already culled down the documents that he thinks, both that are in the sweet spot of, okay, these are national defense information documents, right? So NDI, so pursuant to the Espionage Act statute, that doesn't require it to be classified, just that it requires it to be national defense information. And it's not so secret that even if it comes out at trial, it's okay, because really that's what's going to happen at the SEPA hearing, is they're going to establish what are the procedures that we need to put in place to keep these documents safe, and secret. And sometimes what they do is they'll say, okay, the jury can see it, but it won't be public, so the public can't see it, but the jury can, the defendant can, so they can make their decision. The defense has already signaled in their papers that they're going to object to that. They want everything public. They think that, defendants have a right, and they do have a due process right to an open and public trial. And I'm sure the press is also going to make motions saying, no, we want to see it too. And I'm sure Jack Smith is smart enough to have already thought of that. And so even if these 31 documents come in and everyone gets to see them, I think I think he's already made that determination that will be okay. The problem with that, however, is a couple of things. Number one, the argument the defense is going to make is, well, either it's national defense information or it's not. If it's not that secret, if it's not that big of a deal, then actually it's not that big of a deal that everyone that he had it and that he kept it. So you say that this is, the Espionage Act, this is so dangerous, but here it is. The New York Times published it because it was a matter of public record. And I think that, he only needs one juror to buy that argument. But it's an argument that I think is a pretty good one. Why do you
think? Well, hold it. Why do you think the Department of Justice is going to just not try to protect all the NDI? Because you have three levels of things here, just to be clear for the audience. Espionage Act is not based on top secret or classified. We like talking about it in shorthand because ever since we were kids, we've known what top secret and classified is, like Boris and Natasha for the Rocky and Bullwinkle, show, like a folder. Acme top secret, we get it. But for Espionage Act, it doesn't require that somebody takes, retains, disseminates, uses, discloses, or whatever, top secret and classified. The classification system doesn't matter at all. The reason for that is the Espionage Act was passed before there was a classification system, so it certainly could not have related to that, and Congress never made a change related to it. All that's required is national defense information, NDI, which has only been defined through a series of cases and case law about it. That big pile of documents that Donald Trump talks about on the Bedminster audio recording, where he whips out the Iranian, war map or whatever it was, and starts unfurling it. You can hear it, and people, I'll have a Coke. Remember that audio? That is NDI, and other things probably in that pile are too. If I'm the prosecutor, why don't you just say everything is NDI? Everything has to have protection at the moment from prying eyes of the public. Sorry, we have to put it all under SEPA. Otherwise, you're right. I think they are
going to say that. Yeah. But I think Judge Cannon potentially is going to rule otherwise. Now, the government can appeal that to the 11th Circuit. Trump cannot.
Yes.
And and
Fast
the
track appeal.
but the government's going to have to decide at a certain point, do you want a trial, right? Do we want to have a trial? And if they appeal it, you're again death by 1,000 cuts, right? That fast track, even a fast track appeal that can go up to the Supreme Court, by the way, even that can take weeks, if it's probably not days. And so again, that's going to just be a strategic question that the government's going to have to decide: do we want a trial or not? And the funny thing is, to me, this is a little on its head, because if I were the government, or if I were Trump, I'm not sure I'd be so afraid of a trial in this case. I mean, the fact that he drew Eileen Cannon, forget her. If she has this trial in Fort Pierce, right? If she has it in Fort Pierce and they draw the jurors from her 5 counties that are all red, including Okeechobee County, which voted 72% for Trump, he has a great chance of pulling a jury that it has at least one person who will hang that jury. So I am not 100% sure. Like, if I were Cannon, I would probably push the case and push it for Trump. Let the jurors do the bidding for her. Okay, let's just get this trial out there. Let's get these. I'm going to say these documents. I'm going to call your bluff, government. We're going to get it. And I'm going to put some red meat jurors on there. Let him actually run for president, saying, see, it was a witch hunt. I was acquitted. It was,
But there's an interim thing here that we're missing, having practiced in the Southern District of Florida. No, I'm not calling you out, because I'm just telling you.
It's okay. Go ahead. I want you to.
There's a reason that the final decision about where the trial is going to take place has not been decided yet. And that's going to be in consultation with Judge Altanaga, who's the chief judge of the entire Southern District, who sits down in Miami. We speculate as to why the arraignment took place there. A Miami grand jury that used to be a West Palm grand jury, but because as far as I know, there's no SCIF, which is a place to go look at classified documents in Fort Pierce. I know there isn't. I don't believe there's one in West Palm. There is one in Miami that's next to the Miami courthouse. So be careful what you ask for. If they're too smart by half and they go, gosh darn it, let's have an entire jury pool of Okeechobee County, which is the sugarcane capital of Florida, right at where when you take a shot of Florida from space and you look down, you see that big hole that's in Florida, right? That's the Everglades. That's where Okeechobee County is. But they're worried. They're worried that, the rug gets pulled out from them, because you're right. If they're 100% sure, and they're not, that this could take place in Fort Pierce, where the Fort Pierce jury, let's go. Let's have a trial. We're going to get at least 3 Trumpers in there if we do it there. But they're not sure. And if it moves to West Palm, it's not a Trump place, even though it pulls from Palm Beach County, because Palm Beach County it went heavily Biden, Clinton, Obama. Fort Lauderdale, worse, and Miami. But Miami picks up some red again. It really, it's a weird. Southern District of New York is so much easier to talk about than the Southern District of Florida. But that I think is the reason that they're worried that Altanaga at the last minute goes, who can't handle this case? The court system in Fort Pierce. Let's all come down to Miami. We'll give her a hotel. We'll rent her an apartment. Judge Cannon, you can stay down here. We'll do the jury here. We have the security. We've got everything right here. Let's do. And then they're effed.
Except Trump's lawyers might say, I want it's fine. I don't care where it is, but I want the same trial I would have had. So you're going to bust jurors in from there, which they do in other jurisdictions.
You think they're going to bust them down 100 miles?
You know
every
what?
Day?
They do it in other jurisdictions.
Busing in Florida. It's happened before.
So I just don't know. But anyway, I just think that it's to me, the world is a little bit upside down, because if I'm Jack Smith, I push this trial. We'll see how it goes. And I go for, I would get in there with, whether it's a Bedminster case, whether it's get the Jan 6 case going, and I would push for a better judge, a better jury. I mean, the worst thing that happens is a trial and an acquittal or a hung jury. I think that's worse than putting the trial off.
I think we're going to start, if you and I and Ben are right, and we've been known to be occasionally right. If we're right, this is a portfolio theory for Jack Smith. He doesn't have, where's my finger? He doesn't have one indictment. He has 2 or 3. One could be in New Jersey related to Bedminster bad stuff. One could be in District of Columbia, which is where all the grand juries have been related to Jan 6 and everything that happened from the ellipse to the White House, to the dining room, to the assault on democracy. That's all DC. That doesn't belong in Miami. There is no way in heck that the indictment that we know is coming any minute now, there's this calm before the storm again. You thought last week, I thought definitely this week, somewhere in July, especially now that Fani Willis, and we'll talk about it coming up next, Fani Willis has her Fulton County grand jury seated. Somewhere in there's going to be multiple indictments in different venues against Donald Trump. And is he going to run the table, Donald Trump, and win all of them, including D.C. and New Jersey? I doubt it. But one last thing I want to mention to you, Karen. I don't know if you saw the poll, but there is a poll out that most Americans, meaning all Democrats and a handful of Republicans, want to see the trial happen, not only before the presidential election, before the primary, which is very interesting. 57% of Americans believe that it should be before the primaries, and 62% think it should be before the election. Even 42% of Republicans think that. So that's very, very interesting. I'm not sure Cannon's reading these polls, but that's very, very interesting. We're going to talk next about Trump definitely having a terrible day in court. 2 bad things happened to him on 7/11 in New York in the E Jean Carroll defamation case. And Karen and I are going to talk about that, and then talk about Georgia is on our mind for good reason with the seating of the real indicting grand jury down in Georgia. But first, a word from our sponsors.
And now let's take a quick break to talk about our next partner, Lomi. Now, I've never been able to compost before. It was always too complicated, too much work, and frankly, I don't think I even knew exactly if I was doing it right. Then I got a Lomi. Lomi allows me to turn my food scraps into dirt with just the push of a button. Lomi is a countertop electric composter that turns scraps to dirt in under 4 hours. There's no smell when it runs, and it's really quiet. Thanks to Lomi, I have way less garbage each week. My family, we're down from 3 bags per week to just 1. And here's something pretty cool. My wife, she recently started gardening, and we've been able to use the dirt that Lomi produces to help fill the garden. And since I got my Lomi, I throw out way less garbage. That means it's not going to landfills and producing methane. Instead, I turn my waste into nutrient-rich dirt that I can feed to my plants. I feel so great knowing that I'm composting and creating soil instead of waste. And I have basically a limitless supply of dirt for my garden. The other week I had my in-laws over for dinner, and the food cleanup process was such a breeze. Plus, they all think I'm super eco-conscious now. If you want to start making a positive environmental impact or just make cleanup after dinner that much easier, Lomi is perfect for you. Head to lomi.com/legalaf and use the promo code legalaf to get $50 off your Lomi. That's $50 off when you head to lomi.com/legalaf and use promo code legalaf at checkout. Food waste is gross. Let Lomi save you a cold trip out to the garbage can.
We've all heard the famous line, try it free for 30 days. Yeah, well, that's just enough time to try it and then completely forget about it. In fact, over 80% of people have subscriptions they forgot about. You could be wasting money and not even realizing it. Rocket Money helps you find those forgotten subscriptions so you can stop paying for the ones you don't use. Do you know how much your subscriptions really cost? Most Americans think they spend around $80 a month on subscriptions, but the actual total is closer to $200. If you don't know exactly how much you're spending every month, you need Rocket Money. Rocket Money is a personal finance app that finds and cancels your unwanted subscriptions, monitors your spending, and helps you lower your bills all in one place. Over 80% of people have subscriptions they forgot about, and chances are you're one of them. Like that Stars app just to watch one show, or that free gaming trial you never actually use. Rocket Money will quickly and easily find your subscriptions for you, and for any you don't want to pay for anymore, just hit cancel. And Rocket Money will cancel it for you. It's that easy. Rocket Money also helps you manage all your finances in one place and automatically categorize your expenses so you can easily track your budget in real time and also get alerted if anything looks off. Over 3 million people have used Rocket Money, saving the average person up to $720 a year. Stop throwing your money away, cancel unwanted subscriptions, and manage your expenses the easy way by going to rocketmoney.com/legalaf. That's rocketmoney.com/legalaf. Green Chef is the #1 meal kit for eating clean. Feel your best with delicious, nutritionist-approved recipes featuring clean ingredients with no artificial colors, sweeteners, high fructose corn syrup, and limited added sugar and processed ingredients. Choose from recipes featuring lean proteins like turkey, sockeye salmon, barramundi, tilapia, scallops, and shrimp, certified organic whole fruits and vegetables, organic cage-free eggs, and plenty of whole grain options. Eat the clean, easy way with recipes that help manage your weight and support your wellness goals without skimping on flavor. Feel your best this summer with seasonal recipes featuring certified organic fruits and vegetables, organic cage-free eggs, and sustainably sourced seafood. Also, Green Chef is the only meal kit that has both carbon and plastic offset. Green Chef offsets 100% of the delivery emissions to your door, as well as 100% of the plastic in every box. Plus, nearly all packaging materials are curbside recyclable in most areas of the U.S. Green Chef delivers everything you need to eat clean the easy way this summer. Feel your best with nutritionist-approved recipes, packed with clean ingredients that support your healthy lifestyle and taste great too. I love Green Chef. My absolute favorite is the spicy chicken and broccoli stir fry. Delicious. Go to greenchef.com/legalaf50 and use code legalaf50 to get 50% off plus free shipping. That's greenchef.com/legalaf50 and use code legalaf50 to get 50% off plus free shipping. Green Chef, the #1 meal kit for eating well. You know, it's a hard word to say when you have to say it 6 times in an ad read. I never thought I had a problem saying the word subscription until I had to say it 6 times. but that's the life of a podcast host, or somebody called it recently, oh, you're LawTube. I said, we're LawTube? I didn't even know that was a thing. Apparently, lawyers on YouTube is LawTube, and there's a whole subculture related to it. Well,
Really?
whatever it is, I think we're because of the Meidas Mighty and the Legal AFers, I think we're at the top of the LawTube chain. I hope we are. One of the things that our producer reminded me when we were talking about that calm before the storm, which you so accurately used about a month or two ago to say, you know, we haven't heard a lot about grand jury work related to Jack Smith at that moment. And I bet you he's probably making his presentation to Merrick Garland, which he has to do before he gets his indictment. And boy, were you right. Now we have, for a while, like 2 weeks ago, like, you know, Rudy went in for a queen for the day. Proffer, I always love Rudy as a queen for the day. It's just completely, but, you know, he gave his proffer with his limited immunity, and a couple of other witnesses went in, and then there was silence. Now we have reporting this week that the grand jury met, but no witnesses showed up. That's interesting, because why does a grand jury meet if it's not there to hear testimony? Now, there could be a records custodian who slipped in there. They could be doing documents. They could be doing some other type of presentation.
They could have voted.
Or they could have voted on an indictment.
Exactly.
And so that's where we are. You know, we're trying to read. You know, there are just, and Karen, I know you have it because I have it. You have alarm clocks that are just baked into your DNA as being a trial lawyer that just go off at different times. It's just a level of touch and feel about cases. And we have it here that we apply to the cases that you and I follow at that intersection of law and politics. And things like no phone ringing sometimes is as important as a phone ringing. Right.
You know, you want to know what I thought,
Sure.
I thought of, and I'd love to hear your thoughts. So, you know, there's been a lot of speculation about Rudy Giuliani and whether or not he's flipped on Trump.
Mm-hmm.
And we're not sure, right? And so, but we do know he went in, and his lawyer said it was entirely voluntary. And so let's talk about what it would mean if he were to flip. And I'll tell you, and then you'll understand why I'm saying this. So if he were to flip, which means he would cooperate with the government, and he was clearly a target, he's clearly committed lots of crimes, and he is going to be prosecuted, I would imagine. So for him to flip, he's not just a witness, he's a defendant, I guess, not quite yet, but, a target, and he'd have to plead guilty, and he would have to admit to all the things he's done and really tie up all loose ends. And that's what they make you do in order to cooperate. So we heard this week that he's working on a settlement, civil, but he's working on a settlement in the Shaye Moss, Ruby Freeman, remember the mother-daughter duo who ended up suing him for defamation because he and Trump and others accused them of, taking out suitcases of votes, and they got death threats and all this stuff. And we heard this week that's in, they're very close to a settlement. So I think that means he's wrapping things up, and he's going to flip and cooperate.
Well, except for one, I have to cut in because I have a hot take running right now on the MeidasTouch network. It looks like the settlement fell through because in the filings that the lawyer, which we can talk about, the lawyers for Shaye Moss and Ruby Freeman, the mother-daughter team that were so mercilessly defamed by Donald Trump, Rudy Giuliani, and everybody else, claiming that they were committing voter fraud and stealing ballots and feeding in Chinese ballots into the Fulton County, Atlanta, when they were doing nothing of the sort. They were just counting ballots and putting already counted ballots properly in another pile under the desk in a locked case, which is what they're supposed to do. But in the motion for sanctions and to seek a default judgment against Rudy Giuliani, which is what they've now done, claiming that he has not participated at all, Rudy, in meaningful discovery in the last 18 months. He's produced next to nothing, and has claimed that he's lost it all or never had it or whatever. They've moved for the death penalty for him and civilly to have the case dismissed against him. In it, they said, we thought we had a settlement, but he walked away from the settlement in the last couple of days. And I said in the hot take, because he's both cheap and stupid. But I agree with you. Or he walked away from it because he doesn't care because he's going to be going to jail soon. I've always said that Rudy Giuliani definitely is going to get indicted. Whether he cuts a deal or not, that's a different story. And if he flips, along with Mark Meadows, Donald Trump's time as a free man on planet Earth is coming to a precious few. Because, I've never seen an array of people at the level of knowledge and culpability that are and lawyers that are coming out against one defendant more than Donald Trump. I mean, look, I said to somebody recently, the amount of evidence, witnesses, ex-lawyers, and documents, and video evidence, and audio evidence, and notes contemporaneous that are now amassed and arrayed against Donald Trump. It reminds me of like the parting line. Hopefully it's not a spoiler alert because the season's over. It's like the parting line in Succession when Shiv looked at the mausoleum that now housed her departed father and said, I'm curious to see how he gets out of this one. Same thing here. I'm curious to see how Donald Trump gets out of this much evidence, the mountain of evidence against him. And he'll have to run you may be right. He'll get a hung jury here or there. But he's going to have to run the table in 4 or 5 different criminal prosecutions. All right, and I think that is not only next to impossible, that is impossible.
That's why he doesn't want a trial. That's why he's trying to put these things off.
Right.
No, it's true. I mean, that his entire strategy is delay. Hopefully get the nomination, even maybe get become president, and then he'll for sure pardon Walt Nada, which is what his strategy is. Stick with him, get him elected, and he'll pardon me. And Donald Trump is let's just push this all off, and then when I'm president, no one can do anything. The state they can't.
Gonna be president.
This is what's in his mind.
Yes,
this is what he's thinking. And so that's what he's hoping is put it off, put it off, put it off.
Boogie has a better chance of becoming president of the United States than Donald Trump.
He's such a good boy. He's such a good boy.
Boogie and Lily. Lily can be the first lady along with Boogie. But let's talk about clearing the air here. I'll get back to some serious matters and serious jeopardy for Donald Trump in the E Jean Carroll case. E Jean Carroll, some people might be rubbing their eyes and their ears going, didn't we already do this? She won. Yes, she did win. She won the E Jean, it's weird because she won the E Jean Carroll 2 case because the E Jean Carroll 1 case was put on ice while some issues related to immunity and scope of employment for Donald Trump, who was at one time employee badge number 1 for the federal government as the president. While that was going on, the judge says, yeah, that's interesting. But why don't we talk about and do a trial on things he said against her when he wasn't president? Because we can do that right now. And that was Judge Lewis Kaplan. And I think that was a shock to then the mastermind superhero lawyer Alina Habba, now a spokesperson, now been kicked upstairs and is a full-time spokesperson, and Joe Tacopina, who came in 3 or 4 months before the trial to take over, basically, because they were like, "What? Huh? Don't we have to wait?" Like, no, we're not going to wait. So that trial went forward, and in a Southern District of New York federal case, with a federal jury being pulled from all different places around, Manhattan and the boroughs and Westchester and that kind of thing, and 6 men and 3 women, found that Donald Trump, for the special verdict form, did he sexually abuse her? Yes. Did he rape her? And because of as the former, as Karen, you'll tell our audience again, as a former sex crimes prosecutor, New York is in the minority, and you have to use your penis to rape somebody and not a finger. And most states don't have that issue. So they said, well, she was a little bit unclear. She had her eyes closed. She didn't know if it was a penis or a finger. We'll leave that for another day. And therefore, yes on sex abuse, inconclusive on rape, yes on defamation, yes on punitive damages. Where do we sign? And that was 2.5 hours. Who had the tuna salad? Who had the taco bowl? Okay, everybody's out. The fastest jury is they set a land speed record in finding against him. Only Donald Trump would then use that to say, I've been vindicated. Yes, I'm not a rapist. I'm only a sex abuser. And every time she says rapist, I'm not, because I'm a sex abuser. See the distinction? Not really. I've been defamed, including when E Jean Carroll went on television with Robbie Kaplan, friend of the podcast, her lawyer, and gave an interview and was interviewed by CNN. But before we get to that, because that's really interesting, what happened there and the new retaliatory defamation case that Trump brought against the victim of his sex abuse, E Jean Carroll. The government had something to say after 3 years of sitting around about whether the U.S., the United States of America, was going to intervene in the case related to when Donald Trump used to be president, and whether his defamatory or statements against E Jean Carroll, which are all the same, they're all the same as he's saying now, I don't know her, I never know her, I don't want to know her. She's a hack, she's holding me hostage, she's shaking me down, I didn't rape her, I didn't have sexual relations with her, whatever it is. He says it to this moment. All of that happened. He said that when he was president. So now the Department of Justice has finally got around to saying, will they or won't they come in and give him presidential immunity for that aspect of the case? Karen, what happened?
So look, it's important to just in context understand how it works when you're a government employee. You can't really be sued for actions that you take as a government employee if it's in the course and scope of your duties. And so what happens is this is called the Westfall Act. And if the Department of Justice finds that if you get sued and, in a civil suit, not criminal, right? If you get sued by somebody, if you were a government employee and it was in the course and scope of your duties, the Department of Justice will certify under the Westfall Act and intervene. And what that means is they substitute the United States for the defendant in the case, and the United States cannot be sued cannot be sued civilly. So in this type of context, and so what happens is basically it confers immunity on the defendant. And so Bill Barr, who was Donald Trump's Attorney General, he said at the time that he felt that that the Department of Justice was going to intervene under the Westfall Act. Now, Judge Kaplan, this had sort of a circuitous, went through a whole thing where Barr invoked the Westfall Act, but then which means, because this case was originally brought in state court. So when Barr invoked the Westfall Act, it then got moved to federal court. And Judge Lewis Kaplan disagreed that that Donald Trump was an employee and that this was in the course and scope of his employment. But Trump appealed it to the Second Circuit, which is the appellate court above Judge Kaplan. And they said, no, he is an employee. The president is an employee. But the question of whether this is in the scope of his duties and in his job, that's a question that we have to ask the Washington, D.C. State Court of Appeals to clarify under state law or DC law. And so we had to wait for that decision. And what they said in Washington, DC, what that Court of Appeals said, you know what, that's a fact-based analysis that focuses on the state of mind of the individual. Okay, so Donald Trump, and whether or not it was in furtherance of the job. So it's not automatic just because, on the one hand, you can make the argument that, look, he was president of the United States at the time. When you're trying to decide, is this in the course and scope of your duties, right? He was working that day. He was, with his gaggle of press, people going on to, I can't remember if it was Air Force One or Marine One, or getting off. He was, in transit, and he was answering questions about work. And, it was clearly during a work event, and he was answering a question. And so, there was a question there. Is that in the course and scope of his duties? And so what this now does is this says, this goes to the jury to decide. This is a jury decision, and it's going to trial. But what's interesting that happened here is Merrick Garland, who originally said he was going to stand by Barr's determination and continue and agree that the Westfall Act applies here, has now decided that based on new information, okay, including the fact that Donald Trump keeps making these defamatory statements, right? So it's not like he was just answering questions and that was it. He keeps making these statements over and over and over and over again, including the new ones that are in the complaint, that E Jean Carroll added after the jury found for her in the last case, he defamed her again. He said, the fact that this has continued and there's some other issues, they basically said, in light of the DC Court of Appeals clarification of, liability here, as well as new factual developments, that the U.S. will no longer under the Westfall Act, certify that Donald Trump was acting within the course and scope of his employment. And they go on and say, was the employee motivated to serve the purpose of the employer, and what was on his mind, and what was his subjective intent? And there's no evidence about his state of mind, which is why it has to go before a jury. And they also said, look, even though these statements may have been made during his official duties and using official channels, in a work context, they were purely personal in nature, right? This happened decades before. This was a sexual assault, and and again, his statements continued well after he left office. So, as a result, the DOJ is no longer, they're declining to certify. So bottom line is, the issue here that you've said all along, Popok, is because they've already found that he sexually assaulted her and these statements are defamatory, that it's really all about damages, and what they will be and what the punitive damages will be. But, my question to you is, given the fact that he has made this malicious, horrific counterclaim against a sexual assault victim, in this suit, basically saying that, look, she's not a lawyer. She might not know that New York law is so precise. Most people, when somebody violently violates you, and shoves their body part into her vagina, most people would say, I was raped. And, just because that doesn't fit the statutory definition in New York of the technical definition of rape, that is a rape. He raped her. And so, the fact that he would claim, that do a countersuit against her saying she defamed him is so outrageous that, I hope you can explain exactly how that works and what will happen at the trial with respect to his counterclaim.
Yeah, and I do a hot take on it. I think we're running it a little bit later today to kind of really dig into it. But let me give the high level part of it here. Let me first pick up with something where you left off on the immunity thing, and then I'll bounce into the motion practice, the motion to dismiss against this retaliatory attempt to chill her First Amendment speech, her authenticity, her right to reclaim her dignity, which is all that happened on the CNN interview. Which she had every right to talk about, which was her opinion and her feelings about the jury verdict. That doesn't mean she defamed anybody. On the Department of Justice, I mean, look, two administrations, starting with Trump administration and then the Biden administration, at least the Department of Justice under Merrick Garland, because they're trying to protect principles that go even beyond this former occupant of the White House, right? They have to stand on certain principles. Like, well, we know we don't want to. We're holding our nose for this guy, but we don't like the precedent of having this issue, having the Westfall immunity not apply to certain things. So that's why they've been, for some people, on the wrong side of the net related to people like E Jean Carroll and other rulings that they've taken positions on. That's why. But I do love the fact, as you noted, that they pointed out, well, let's look at the continuum of his actions, both while he was president and after, to answer the question that we have to answer based on the appellate court's ruling in the District of Columbia Court of Appeals, not the federal court, but the territory of the District of Columbia's highest appellate court, which is, was the conduct, in this case, defaming her, actuated at least in part by a purpose to serve the people in the U.S. government? That's the phrase, actuated at least in part by a purpose to serve. So there's two components to that. One is the quantum, right? How much of what he said was because he was protecting the office of the presidency and doing his civic duty as president, and how much of it was just private BS about activities that happened before he was president. And then what was the purpose? So it's a quantum element and purpose element. And they pointed to his continued social media postings in which he goes after her the same way now, the same way today as he went after her then, to say, well, if you're doing the same thing then and the same thing now and the same thing then, and hopefully we can put up some of these posts here while we're there. We are right there. This was this morning, right? So they compared that and earlier ones that were identical, and I'll read some of these out loud, to what he said as president, and said, see, he's not serving as president in this role because he's doing it now when he's not president. So I love Donald Trump. He has a 3-part social media posting, and he puts it down as page 1. I don't know why it's pages. It's screens if it's anything. Page 2 and page 3. Page 1. The Department of Justice will not defend me in the E Jean Carroll civil case. You can bet your sweet ass they're not. Which is all a part of the political witch hunt, lawyered up by a political operative who I just beat in another case. I'm not sure who that is. Financed by a big political funder. So he's saying the political operative is E Jean Carroll because her law firm took some minor cost funding from the founder of LinkedIn. Just like Donald Trump uses Save America PAC to pay millions and tens of millions of dollars to people for his law defense. Okay, So that's who he's referring to there. E
By the
Jean
way,
Carroll.
Popok, I think he says who I beat in a prior case. I think he's referring to the fact that the rape. Yeah, he thinks he won.
He thinks he was vindicated because he was a judge, the sex abuser, and not a rapist. So that's the person he beat in the prior case. She's a political operative because she's a Democrat. Okay. And she didn't take it. Her law firm had some of their costs defrayed because they were doing this on a contingency basis, meaning they weren't getting paid. And there's a lot of cost in cases like this, hundreds of thousands of dollars of deposition transcripts and experts and all this thing. And so Reid Hoffman from LinkedIn paid some of that. Okay, so what?
Who takes that as a win? Just who
an
thinks?
Insane narcissist, megalomaniacal former president. He then goes on to say that he was judged by a Clinton appointee. Okay, all federal judges are appointed by some president, including a number that were appointed by Trump, who truly hates Trump. I love when he talks about himself in the third person. The statements that I made about Carroll are all true. Yep, here we go. Didn't know her, didn't sexually abuse her, she's not my type. I didn't rape her. I won that at trial. Here's your point, Karen. I won. I'm only a sex abuser. And other than for this case, I have no idea who she is, what she looks like, or anything about her. Then he goes on to say the Carroll civil case against me is a miscarriage of justice and a total scam. Trial was very unfair. Trial that he did not attend. A trial that he chose not to testify in, either though he didn't have a criminal case against him. So there was no Fifth Amendment problem. He just chose not to attend. He acted at a press conference in Scotland when he was at a golf course, like, oh, I'm heading back to testify or to attend. Never did.
Can anyone, just really quick, somebody point out, he says he's too busy, to go to trial in Mar-a-Lago. He can't possibly do it because he's running for office. Well, how come he has so much time to play golf all the time? He's always on a golf course. He's not that busy.
Well, he's not employed. Let's be honest. He doesn't have a job. Then he goes on to say in this social media post, I was unable to, the trial was very unfair with the other side being able to and present virtually anything they wanted. Yeah, the judge ruled against you on a number of evidentiary issues. You had no witnesses. She had 11 witnesses. You had no expert. She had 2 experts. She testified and you didn't. Any wonder the jury ruled in 2.5 hours against you? An out-of-control judge, the same judge that's going to be deciding all these issues. My lawyers, due to their respect for the office of the president, oh, here we go. He's deluded again. Skipper thinks he's the president again. And the incredulity of the case did not want me to testify. Oh, here we go. Now, if you let's blow that apart. Joe Tacopina said, you know what I'm dealing with here, Judge? And the judge says, yes, I do. I'm going to give you one more chance to get if he wants to testify, he shows up Monday or not, or he's waived his right to testify. That's now been misinterpreted by Trump in lying to the people that his sycophants, his cult followers, as being, I wanted to testify, but out of respect for the office of the president, he did all this in 1996 when the only office he occupied was some bachelor pad at Trump Tower across the street from the department store where he sexually abused her. And then he ends it with the net result of this horrible injustice when a completely unknown to me woman made up a ridiculous story. I'll remind everybody that there is a nice photo of him meeting her laughing at a gala along with her husband, who was then a very well-known John Johnson, who was a very well-known, do you remember him on ABC News? He was a very well-known newscaster. And that's the famous photo from the deposition where he mistook E Jean Carroll for his other wife. He was standing next to Ivana, but mistook her for his other wife,
Marla Maples.
Marla Maples.
Can you imagine?
He thought he was in a photo with his current wife and his future wife and some random African-American man. When it was really
Can you think, Popok? No. Can you think of a greater gift? If you're Robbie Kaplan deposing Donald Trump and you show him that picture and he mistakes her for Marla Maples. Can you Robbie Kaplan
salivating.
Must have been like, thank you, God. That is the greatest answer Like that doesn't
No, it's a
happen.
gift.
That's
No,
like Perry Mason stuff that happens like,
It's like
on
television.
TV.
It's like Law and Order where you sometimes work. And then of course everybody in that room knew that Grandpa Trump, he keeps making fun of Biden because he gets tongue-tied occasionally as a lifelong stutterer, and because he's 80, he made fun of him saying, "Oh, he's losing it." Really? How about you? How about you, Grandpa? You thought both your wives were in the same photo at the same time, and it was so bad that Alina Habba jumped in like the nurse to say, "That's Carol." I mean, and I would have jumped out. I mean, I give a lot of credit to Robbie for holding her fire, because I would have said, Miss Habba, you are interfering with you're littering and polluting my transcript. She just sat there.
Said, Miss Habba, you can't put the toothpaste back in the tube.
That's
Whatever.
Carol. And then he said, that's, we have the transcript. That's Carol? Yeah, that's Carol. That's E Jean Carroll, you lunkhead. Just destroyed your own case. Are we going to play this?
Oh, God, please.
Salty doing, we're not going to play. Salty just told me, he just burst my bubble. But there it is when he was testifying. All right. So now let's talk about the motion to dismiss briefly. He files a retaliatory strike against E Jean Carroll because she went on CNN, and in a 5-minute interview, a reporter turned to her with Robbie Kaplan, her lawyer, next to her, and said, "What was your reaction inside you when you heard the jury return the verdict and finding sexual abuse, yes, but rape, no?" And she very authentically and really, to reclaim her dignity, because it's true, said, "I thought that's not true. He raped me. But I'll leave it to my lawyer to talk about the legalities of it." She was very polished on this point. That is all true. Her opinion is true. What she felt is true. She can disagree with the jury. She's allowed to say that. And she's allowed to say also the other aspect of the defamation case is that Joe Tacopina came over to her at the end of the trial to shake her hand. I guess he was trying to be chivalrous in some way. And she said to him, "He did it," meaning Donald Trump, "and you know he did it." And she walked out. And that for Donald Trump was the last straw, because that's her calling him a rapist again. So the motion to dismiss, which is scathing against Donald Trump and just repeats all of the evidence against him, methodically, painstakingly, what the jury was told about the sexual assault, the abuse, the rape, the whole thing, and then says to the judge, "Look, Southern District of New York sits in the Second Circuit for appeal. And Second Circuit has clearly said that defamation cases are special. And if you have somebody like Donald Trump bringing a defamation case against a victim like this, power disparity, it's often seen as a chilling attempt to stop First Amendment speech, proper First Amendment speech. And you can decide this right now at the pleading stage. You don't have to wait for summary judgment. You don't have to wait for discovery. Do it now, judge, because otherwise you're going to be rewarding him for weaponizing defamation law." She was only fairly reporting what happened in the courtroom, and there's a privilege for that in defamation law. She was giving her honest opinion, and whatever she said was substantially true, because sexual abuse versus rape to the average person is really the same thing. And the thing about Joe Tacopina, she just said it, and that can't be the basis. And then finally, because Donald Trump is Donald Trump and E Jean Carroll is E Jean Carroll, in order for her to defame him, he has to prove that it was done with actual malice, meaning that she knew what she was saying was false and or recklessly disregarded the truth or falsity. And they told the judge in the motion to dismiss, he'll never be able to do that. Dismiss the case now. I think that case against E Jean Carroll gets dismissed right now by Lewis Kaplan, and then we move on. I think just for shits and giggles, we have the video of Donald Trump mistaking E Jean Carroll, the woman he said he didn't know, for his own at least second wife in the video. Let's go, and then Alina Habba jump in.
Play it. Come on, we got to play.
I don't even know who the woman. Let's see. I don't know who. It's Marla.
You say Marla's in this photo?
That's Marla. Yeah, that's my wife.
Which woman are you pointing to?
No, that's
Here.
Carroll.
Oh, is that?
The person you just pointed to was
I
E Jean
see.
Carroll.
Who is that? Who is this?
Point, your wife.
And the woman on the right is your then wife,
I don't know.
Ivana?
This was the picture.
Ivana.
I assume that's John Johnson. Is that
That's Carroll.
Carol? Because it's very blurry.
Yeah, okay. First of all, he stares at the photo. He didn't glance at it. He stared at it for a good minute or two. And then he said, because, he's the smartest guy in the room, well, that's Marla. Right. The picture, which we could find also, he's standing next to Ivana, right? So you see Ivana with a big boof of blonde hair and her mink coat, and he's there. And then you see straight in the middle of the shot, a very young, because she was young in the photo at around the time of it. And he keeps talking about, I wouldn't sexually abuse a 78-year-old. Well, first of all, you're 78, and we're not talking about now. We're talking about in 1996. So here's the photo in and around 1996 or the late 80s, what she looked like. And yes, it is his type because he thought it was Marla Maples. Only he's delusional enough to think he's got two wives in the same photo. That's what I'm going to...
No, it was blurry. It was blurry.
Okay. Let's let the audience
By the
decide.
way, that's the least blurry photo I've ever seen.
That is the clearest. You would think in 1985, whatever, this was the, like high def iPhone. Okay, that's because it was a photographer, a real photographer, the real camera. For you kids out there, we used to have cameras. This is a real photo. That is John Johnson, who was a celebrity local newscaster on ABC News here in New York. On the right with the big boof is the late Ivana Trump. And looking right at Donald Trump and smiling along with John Johnson, because Donald Trump said something funny, I guess, is E Jean Carroll, not Marla Maples. That's why he lost. That's why he lost this case, because that was put up in front of the jury. And that's why he's a total buffoon and a liar. So that's what's going on 7/11, 2 filings. Department of Justice gave him one gift, which is you're on your own, Don. No sovereign, no presidential immunity for what you said when you were president, because you're outside the scope of your employment duties, and motion to dismiss, which will likely be granted. Next step is, I guess the Trump's going to argue somehow that he's entitled to immunity. The judge is going to have to decide, but that's up to the Department of Justice. That's up to the U.S. government whether they're going to assert immunity. They can't get an appellate court. I mean, he can try to take an appeal, but it's not happening. He's going to go to trial in E Jean Carroll, Roman numeral 1, on a $10 million punitive damage case, at least in the next several months. And you and I are going to be here to report on it. But before we go to, of all places, thank God, Georgia. I got Georgia on my mind, and talking about a real grand jury that's got the power to indict, that has now been selected, 2 separate grand juries side by side. We'll talk about those and what happens on Tuesday when they meet and start considering the evidence against Donald Trump brought by Fani Willis, the Fulton County prosecutor. But first, we need him. We need him to keep the show on the air. A word from our sponsors. This podcast is sponsored by Miracle Made Sheets. Whether you want to get more fit, be a better parent, or get more done at work, there is one thing that will help, and that's better sleep. With Miracle Made Sheets, you can tap into the power of self-cooling temperature regulation, which has been shown to improve deep sleep quality by over 20%. Using silver-infused fabrics originally inspired by NASA, Miracle Made Sheets are thermoregulating and designed to keep you at the perfect temperature all night long, so you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them cleaner and fresher 3 times longer than other sheets. No more gross odors. Miracle Sheets are luxuriously comfortable without the high price tag of other luxury brands, and feel as nice, if not nicer, than bed sheets used by some 5-star hotels. Stop sleeping on bacteria. Clean sheets mean less bacteria to clog your pores and fewer breakouts and other skin problems. Go to trymiracle.com/legalaf to try Miracle Made Sheets today. And with Mother's and Father's Day right around the corner, this is the perfect way to give someone you love the gift of better and more luxurious sleep. Save over 40% and be sure to use our promo code LEGALAF at checkout to save even more and get 3 free towels. Miracle is so confident in their product, they backed it with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LegalAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself. Thanks again to Miracle Made for sponsoring this episode. When it comes to privacy, people tend to focus on things like tracking cookies and browsing history. But protecting your email privacy is even more important because emails contain a lot of personal and sensitive details, such as financial and health information or login credentials that you don't want falling into the wrong hands. That's why I use StartMail, the secure email service that keeps your inbox safe. Every day, millions of people unknowingly risk their sensitive information through insecure email communication. Regular emails are like open postcards, accessible to cyber criminals, companies, and even government agencies. Your free email provider has extensive knowledge about you, including your purchases, web activity, YouTube searches, reservations, subscriptions, and location history. Gmail, Yahoo, and the other popular services, they scan and analyze the content of your emails to generate targeted ads. They also keep copies of your emails, sometimes for months after you deleted them. This means that any email can be retrieved from your account if needed and shared with third parties, such as government agencies. If you're sick of all this nonsense, then you need to give StartMail a try. StartMail makes it so easy you can enjoy secure email communication without surveillance or ads. StartMail ensures your inbox is protected with advanced security features. Plus, you get 20 gigabytes of email storage, surpassing what free providers like Gmail offer. StartMail has world-class encryption for confidentiality, which allows you to send encrypted emails even if the recipient doesn't use encryption. Your confidential messages stay private. And when you delete an email, it's gone forever. Switching to StartMail is hassle-free, and its easy migration tool allows you to move your emails and contacts from Gmail, Outlook, Yahoo, and other providers with just a few clicks. Our daily lives rely on the internet. Email privacy is crucial to protect personal and sensitive information from unauthorized access. Protecting your information is about safeguarding your rights to free speech and association, not about having something to hide. Sign up today and save 50% on your first subscription year. Go to startmail.com/legalaf and join tens of thousands of people who trust StartMail for their email security needs. That's StartMail with a T, startmail.com/legalaf for 50% off. And we're back. Support our sponsors. I know people are like, oh, there's another ad. Thank God there's another ad, because it keeps the network alive. It keeps the content coming to you, flowing the way that you like it. You don't pay for this. It's free subscription to the MeidasTouch YouTube channel, and audio podcasts are free. But, we got costs. And so our sponsors...
And we got Salty. It pays for Salty, who,
well, that's a cost.
Look how great. But here, look, you and I go off on these tangents, and we start talking about stuff, and he finds the videos and the clips, and he's just right up there with everything. So
and these sponsors are supporting pro-democracy, progressive, ideals. The way that we curate our sponsors, we don't take them all. We like the ones that are supporting us. And so, all right, enough of that. Let's get to Georgia, Popok. All right, here we go. I'll frame it, turn it over to the prosecutor, and then here we are. Fani Willis in March, was it March? Was able, after 7 months with a special purpose grand jury, to get a report and recommendation and a referral, if you will, of Georgia election interference crimes committed by Donald Trump, Rudy Giuliani, and others, including the fake electors, the head of the GOP, the Republican Party in Georgia. A lot of different people were targets of the special purpose grand jury to help Fani Willis make the ultimate prosecutorial decision, which is her decision to make in Atlanta about whether to seek the indictment of a president. Now, by the time that started, and we're now talking about these things in the middle of July, that former president has already been indicted twice. So breaking the glass ceiling is a little bit less. It's important, but it's not as shocking as it was now that Alvin Bragg in the Manhattan DA's office and Jack Smith's team have already gone forward. But very, very important, because Fani Willis is not only, we believe, looking at Georgia election interference, starting with the phone call that Rudy Giuliani made, that Rudy Giuliani, Mark Meadows, and Donald Trump made throughout the state, but particularly the Mark Meadows and Donald Trump phone call, searching for 11,758 votes between friends. Let's throw out some ballots. Let's throw out some absentee ballots. Let's throw out democracy while we're at it. And all the other things that happen in the state, including led by Rudy Giuliani in the courthouses and setting up the fake electors, and then plugging that into 6 other battleground states, because, like a Marvel movie, Donald Trump needed all 7 jewels in order to have the power to destroy the earth, and so he needed Arizona and Michigan and Pennsylvania and Georgia, and so she is bringing a conspiracy, we believe, count case against Donald Trump. That's what she's fashioning. She has a civil RICO expert, Racketeering Influence and Corrupt Organization Act, which used to go after the organized crime and the mafia, but it's going to be used against Donald Trump to tie together all of these disparate acts, conducts, and people in one speaking indictment. That wasn't in March, because that grand jury was advisory. But then she takes that report, Fani Willis and her team in Atlanta, Fulton County, and then she said indictments are imminent. And by imminent, she meant, I guess, August or September, because she's continuing to develop evidence in the case. She's got more cooperating witnesses, including a lot, if not all, of the fake electors who have all said, we don't want to go to jail for Donald Trump. We'd rather cooperate with the prosecutor. Good idea. And others. Lindsey Graham has testified, and Rudy Giuliani went and talked to the special purpose grand jury. So she's going to be able to use the 75 witnesses that already went before the special purpose grand jury and their testimony, which has been recorded, at least transcripts, and use that in Georgia, because Georgia, unlike other places like New York, hearsay is okay. So you don't have to have the live witness. It's okay if one person in her office sits there and says, I'm now going to be Rudy Giuliani. This was Rudy Giuliani's testimony. Question, whatever that answer. And that goes on for an hour or two until you bore the grand jury to death. But you also can bring in live witnesses, of course, to supplement all that work. She's not going to walk away from 7 months of work and a report and witness transcripts of 75 people that she already developed, Fani Willis. She's going to bring that across the street to a new grand jury that as of yesterday is seated. And there's 2 of them, 26 apiece. You got 52 total grand jurors. And one of the reasons is, first of all, you need to have this is the regular grand jury, meaning garden variety crime that goes on in Fulton County needs to have indictment through grand jury. So you bring in the larceny, the battery, the murder, the kidnapping, the whatever, and on they meet twice a week for a couple of months. So these 2 grand juries are necessary just because of the volume of crime that's in cities. They got to have these grand juries running. And like one day they'll be, or one part of the day, it'll be like, let's talk, indictment related to, somebody brutally beat up somebody else. Okay, fine. And then it'll be like, okay, now we're doing the Donald Trump one. And we're bringing in the witnesses. Same grand jury. They just wear a different hat. In order for the grand jury to, and why there's 2 of them is because one is going to be doing a lot of full-time Donald Trump. And the other is going to be doing the other ordinary crime, garden variety crime that happened in Fulton County that needs to have prosecutors seek indictments. We don't know which is which yet. They don't know which is which yet. When a judge on Tuesday, when they get to work and there's a new judge assigned to oversee that process, we'll know which is which. But I'm going to do one last stat and turn it over to our former prosecutor, Karen. For those that are wondering, as I opened the podcast, how many do you need for a quorum? In other words, how many have to be there to meet in order to do business of the grand jury? And how many do you need for an indictment? So out of the 26, you need at least 16 to be present. So 10 can be absent at any given moment when evidence is being presented and all of that. That's a quorum for the grand jury to do its work. If they got 15, they don't have a minion for the people that are Jewish out there. They can't do it. Oh, we got to get that 16th person, get that person in the box. Okay, now I can present my evidence if I'm the prosecutor. But if they have 16 or more, up to 26, they can go forward, and that's a grand jury day. That's a day of presenting evidence, witnesses, reading things from the special purpose grand jury report, and all that. Then on the day they seek the indictment, they got to get 12 out of 16. Have to be the 16 there for the quorum, and 12 have to raise their hand and say, I indict. So 4 can hold out. This is Fulton County, Georgia. This is a Democratic bastion. When she seeks that indictment of Donald Trump, which she's going to do, she is going to get an indictment of Donald Trump for civil conspiracy and fraud and election interference. No doubt. And we'll continue to cover it as we go along. What did you make of the pictures that have come out about the grand jury process already, the seating of 2 grand juries? You've been in front of grand juries. You've done high profile. There's Fani Willis right there, real time, coming into the courtroom for the grand jury with her team. You've done it, Karen, and talk about the grand jury process, how you interact with them. How does that differ from a regular grand jury in terms of how you treat them, information that you give them? Kind of let people in under the hood of the grand jury process from your perspective.
Yeah, sure. So I've presented, I would say, thousands of cases before a grand jury. I've been in many, thousands of grand juries. I've even impaneled grand juries, which is what the process is called when you choose a grand jury and you make them an official body. So I've done this more than almost any other thing in my entire career. So let's talk a little bit about what a grand jury is and what it's not. So a grand jury is not the same as a regular jury or what they call a petit jury, a trial jury. They're very different. So a trial jury in a criminal case is the jury that hears the ultimate facts at the end. And what they actually hear is a much more fulsome presentation where there's both direct examination, the statements from the prosecutor side, and cross-examination. And they have to find unanimously beyond a reasonable doubt. And that's the legal standard, right? It's beyond a reasonable doubt. A grand jury is very different. A grand jury is a charging body. It's literally what you do is you present evidence to see if there's sufficient evidence to charge someone with a crime. And the standard there is much lower. It's not beyond a reasonable doubt. It's probable cause or reasonable cause to believe that a crime occurred. There is no opening statement, there's no closing argument, and there's no cross-examination. It's just they listen to evidence, and it's the evidence that the prosecutor presents, and a defendant has a right to testify in the grand jury as well if they want. They have to waive immunity if you're in a grand jury that confers immunity, and that's what they do in New York. If anyone who goes into a grand jury gets automatic immunity for those crimes, and so you have to be careful who you put in unless they waive immunity, including a defendant. Now, here, the way it works with a grand jury is just like any other jury. You get a summons and you show up for jury duty, and you are told you are part of the grand jury or you are part of the, petit jury, the trial jury, and the fact that they impaneled 2 grand juries is still not necessarily that much, because in New York, for example, just in Manhattan alone, New York City is 5 different boroughs, right? It's Manhattan, Bronx, Brooklyn, Queens, and Staten Island. And in Manhattan alone, we have 4, 5, 6 grand juries going at all times. It just depends because of a volume. And so, she has 2 grand juries that are going, and again, in Manhattan, they sit some of them all day, every day, some just the mornings 5 days a week, some just the afternoons 5 days a week. It's just really a matter of scheduling. But you will know when you are serving grand jury exactly how long it's going to be, what days you are going to serve, and you are there to hear this evidence and determine if there's probable cause. Again, it's a much lower standard. It's not like it's not like beyond a reasonable doubt like at a trial. So that's why they call it bare bones typically, because you don't have to present everything. You present just enough that the jury needs to make an indictment. Now, in a case like this where they're going to charge RICO and or conspiracy, as well as the other charges. This is fairly complicated. They are going to get lots of evidence, whether through documents, whether through live witnesses, or whether through the reading of the report or summarizing the report or the witnesses that testified for the special grand jury that you talked about. It's going to take some time. And the way it works is here, so they picked 26 grand jurors per grand jury. So there's 23 who are the actual jurors and 3 alternates. So the 3 alternates who are going to sit there aren't going to do anything unless someone who is a juror can no longer serve, and then they are substituted in. The way it works in the grand jury is grand jurors can ask questions and they can participate, but it's really more of a passive. You sit there and you listen, and the prosecutor asks questions of the witnesses. So there's really only 23 grand jurors who are impaneled at a time. And as you said, for there to be an indictment, there has to be a quorum, which is at least 16 present. It's not just actually for an indictment, it's also to hear evidence. The grand jury can't function as a grand jury unless there's at least 16 of the 23. That's called a quorum. And if they have a quorum, then you can present evidence. And then, as you said, to get an indictment, you need 12 votes in favor. Now, a couple of things. First of all, nobody is ever going to take a vote if there's unless it's like an emergency, no one's going to take a vote if there's only 16 of the 12 present. You're going to want the whole grand jury there for a few reasons. Number one, occasionally a grand juror will miss a day here or there of testimony, right? The doctor's appointment, they'll be sick, whatever. And there's a roll call sheet, and you can only vote. A grand juror can only vote on a case if they were present for all material evidence, right? Anything that's material. So, a prosecutor's not going to take the risk if there's only 16 present, that what if, a couple of them weren't there, and a judge disagrees with me and rules that, this was material that they missed. I thought it was ministerial, but it's material. No one's going to take that risk. The other risk a prosecutor's not going to take is, you're counting on 12 people to vote out of 16. You're not going to want to, they're good odds, but they're not perfect, right? In a case like this, I think you're going to encourage the grand jury to all be there all the time. And you're going to want as many as possible in order to ask them for a vote. So, that's what's going to happen here. Next week, Judge McBurney is going, he already explained to them their responsibilities and the purpose, et cetera. And next week when they start, if they haven't already, they're going to be sworn in. And then there's initial charging that happens, right? And in New York, I guess there, Fani Willis and the judge already did it. In New York, the prosecutor does it. There is no judge. The only function that the judge does in New York is he's there for the selection and for the swearing in. And then they go into the grand jury, and then the prosecutor is the one who charges them on the law in New York.
Ernie's out after yesterday. He's a new presiding judge will be over the 2 grand juries.
Interesting. And so, that's how it's going to go. And, I think that we will see, Fani Willis has very loudly signaled exactly when this is going to happen. She's shutting down the courthouse when it happens. She's letting law enforcement be ready. And I think that's great. I think she's also signaling to Jack Smith that, if you want to go first, this is, you better do it before. And I think there's reasons why she'd want him to go first. I think one of them is, there is this policy at the Department of Justice called the Pettit policy, which means if there's a state court went first, there's a policy to stand down. Now, it's only a policy, you can override it. But again, Jack Smith and Merrick Garland, they're not going to want to look like they've done anything special here. They're going to want to go first. They're not going to want to say that we're going against our policy, even though they can, because it's not a law or a rule. They're not going to want to be put in that position. So I think we're going to see Jack Smith go before Fani Willis brings this case. I think Fani Willis's case is going to be sweeping. I think it's going, in addition to all the charges that you talked about, I think it's going to be lots of people. I think you're going to see lots of defendants here, And I think it's going to be, a sweeping indictment that focuses on the nationwide fake elector scheme that Georgia was one of the jurisdictions where it happened with the, find me the 11,780 votes.
Yeah. No, that's where that little bit of competition for justice is going to happen, because we know Jack Smith is looking at the 7 battleground states and the fake electors, and Fani Willis signaled, I'm not sure how much dialogue the Department of Justice and Fulton County DA have had, but she's told the world that she's also expanded hers, because she's right. Georgia was one of 7 places that Donald Trump tried to falsely and fraudulently interfere with the election. He didn't make just one, when we first started the show, or, I don't mean this show, although this show is going on. When we first started the show, we were always talking about the phone call that Donald Trump made to, Brad Raffin's Perger to talk about, can I just find 11,000 votes? Turns out that wasn't the only phone call that Donald Trump made. He made one to Arizona. He made one to Pennsylvania. Donald Trump violated every rule that he lived his life by that Roy Cohn had taught him, his former fixer before Michael Cohen. Roy Cohn told him, don't put anything in writing. Don't make any phone calls yourself, and use buffers. And he did that his whole life in business. That's why he was ripping up presidential records, to the aghast response of his staff, who then scurried to paste it back together again after he left the room when he was president, because he had always done that when he was in business. He never wrote anything, took that stupid Sharpie and would write a one-liner on it, but he never made phone calls. He got so desperate, and thank God he did, because that's the evidence we need to convict him. He got so desperate at the end to stay in power, when the reality that, to quote him, I can't believe I lost to that guy being Joe Biden and the proper election. Yeah, you lost. But he couldn't accept it. He started picking up the phone himself. Multiple phone calls, some of which got recorded, all of which got noted in some way. And that is great for justice. And that's that battle between Fani Willis and Jack Smith about who's going to do the big, giant RICO civil case, this sprawling case with witnesses and documents and states involved, him or her. And I think you're right. I think it's going to be Jack soon. I know you thought last week. I thought this week, maybe next week. But I think it's a July before Fani gets out of the chute completely case. And so to answer the question in the chat, what happens to Fani? Fani Willis says hers will be stayed. It'll be abated while it doesn't get canceled out necessarily until the federal case goes forward. And then Fani Willis continues to try her case after she's reached her indictment. But look, Karen and I will follow these things the way we have, hopefully meticulously putting together and tying together and painting together all the little dots that, we're discovering our fan base, our followers, listeners, and audience are following and sending to us. We have a lot of dialogue with people that are here on the chat tonight, and also, in our own social media. You can follow me on all things social media, including Threads at MS Popok. Karen, I know you're on Threads as well. Give your social media handle.
I think I'm Karen Agnifilo on Threads, because your handle has to be the same as your Instagram handle. That's how it works. So I don't know.
You're KFA legal everywhere else.
But on
Threads, you're what?
At Karen Agnifilo.
Oh, okay. So, we're trying to use Threads. I'd love to get off of Twitter, but for right now,
I would love to get off of Twitter too. It's funny because people are like, well, I don't understand. You're just going from one, megalomaniac billionaire to another. And I understand the concern and the issue, but, just the hate speech and, other things that Elon Musk is bringing into Twitter, I do think at least Threads says they're going to be much more responsible and have a policing function for the hate speech and the misinformation. So I think for that reason alone, I think it's just time for something new.
we're all scrambling to try to figure out what's the next thing that's going to be what's the reef that all the cool fish can hang out on. We don't know what it is yet. I mean, back when LinkedIn is now the dominant business, social network. Okay. But when LinkedIn first came out, I don't know if you remember this, Karen, because you and I were doing the same thing. There were so many competitors for LinkedIn, and I get all these weird invitations from join me on this one and join me on, and I was like, oh my God, how many are there? And then LinkedIn leapt to the front, crushed the other ones. Everybody just stayed there. And that's what happened with Twitter. It wasn't that it was the best or greatest with the word limit and the whole thing. It was sort of hokey, but it's where everybody just gravitated to, and it got a center of gravity about it, and everybody just stayed there. We're trying to find the next thing. I'm not here to plug anybody else, but Threads just did sign up 150 million people in a week and a half or whatever it is. So yes, it is one evil billionaire against another, but that's who owns media companies, except for the MeidasTouch network, which we don't take outside money, which is why we have sponsors. Haven't I rounded that out nicely to end our show?
Yes, and you can always find us on YouTube, as Salty just reminded us in the chat.
And you can always find us on YouTube for free subscription only on the MeidasTouch network. We've reached the end of another midweek edition of Legal AF. I think we're coming up between the two shows on the one podcast. We're coming up on like 300 in terms of our episodes. It's amazing. Coming into summer season again, but justice doesn't sleep or rest. Neither does Ben. Neither do I, apparently. Neither does Karen. So we're going to keep it coming every week, just like this one at the intersection of law and politics. We are so grateful for our audience who's been with us through thick and thin. It started thin. It's getting a lot thicker, which is good. Shout out to the Meidas Mighty, the Legal AFers, and Karen, as always. Although people say, yeah, you're like Ben, though. Sometimes you tell Karen she has the last word, but then you take it back. All right. It's a phrase. Get over it. You know how many times Ben's giving me the last word and then goes on for another 25 minutes on some rant? It happens. It's the show. It's the beauty of the show. That's why we like doing it. Karen, a word.
I have two questions and then a comment.
Okay.
Question number one, what was the first date of the first Legal AF with you and Ben? And is it still available on YouTube?
Well, it depends. Salty's probably scrambling right now. I hear fevered fingers on clicking around. I know. He just said I am in a chat to me. It depends. It depends on how you define it. Ben and I started something called, just terribly named, Legal Roundup, which was terrible.
It's better than Raw Law.
No, it wasn't Raw Law. Trust me. It was Legal Roundup. Thank you, Salty.
April 6, 2020, he says.
He dates it as April 6, 2020, which is like it was a pandemic project. Okay. MeidasTouch had just started. It had like 3,000 people on it. It was so MeidasTouch. I'll tell secrets now. MeidasTouch was really a website before it became a podcast and then a YouTube thing. And it had people on it. And they needed so much content that I used to send videos from New York of like random things. And then Brett and the brothers would get it up immediately because they needed content desperately. So I'd be like, look, Super Mario go-karts going down Fifth Avenue because of the pandemic. And they'd be like, Super Mario takes over New York. Or like people not wearing masks. Remember when that was a thing in the middle of the pandemic in Washington Square Park? Look at this video. And they'd put it up. Eventually, Ben and I were like, we're lawyers. Maybe we should do something related to the law. And I would do these little whatevers. We didn't know what they were. And then we did Legal Roundup, which was much better on graphics than it was on content because Brett Mycelis did the graphics. We didn't have Salty then. And we had 175 total, not thousands. We had 175 total views. I think our first episode, our second one, I think was 250, something like that. And now if you and I and Ben don't do 500,000, we're like, what did we do wrong? What is the matter? We're doing something wrong. I'm like, doing something wrong. I was in a closet with 254, for all I know, cats and dogs watching, and we were high-fiving. We're like, this is great. That's people I didn't know. They tuned in. That was the way it worked. And then we were like, and then as I said before, we were a special edition. Once the Meidas Brothers podcast got popular, we were a special edition. I have a funny story about the YouTube part. And we just started, the first 15 episodes was just me, special edition with Ben on the regular Wednesday MeidasTouch. It was like, and we didn't have a name yet. And then we did Legal AF, tried Legal AF, which I came up with. And then the funny part is, Brett, I noticed that the brothers were doing YouTube. And I used to get dressed up for the podcast until Ben broke it to me that we were only doing audio. I'm like, well, why am I wearing a nice sweater then? Because I don't know. So we were only audio, and I was like, well, why are the brothers YouTube? Oh, yeah. And I think Brett thought that it would be better, like that I had a face made for radio, maybe. And maybe Ben did too. So he was like, no, you guys are doing good. Do audio only. We don't need to see what you guys look like. And then we said, well, no, let's try YouTube. And then YouTube took off, and the rest is history. And then you and I met. And the
when
rest
was that?
history.
When was our first episode?
I don't know, maybe 4 months later, 5 months later. I was like, I want to do a longer, as this has become, I want to do a longer version where we can really drill down on things, and we want to get some other voices on here. I think it was like, you were like 50 episodes in to the beginning, but you're a founder. I consider you're not like the second Darren on Bewitched. You're the first Darren.
Second Darren on Bewitched. Oh my God, that's the best ever.
You're the first Darren. You're not the second.
Wait,
Darren.
what was his? They had the same first name, both of them.
It was one was Dick York and the other one was Dick Sargent. And don't ask me how I remember that.
Okay, and how I remember that they had the same first name. Okay, that's crazy. All right, we got to go. Salty's gonna.
All right, we got to go. We've lost all the audience. Okay, shout out to the Mighty, the Legal AF. See you next week. See you on Saturday with the Saturday edition.